Good afternoon, attendees. This is Beth Overmo. I am the Strategic Plan Coordinator for the CR. Wanted to just give you a few housekeeping items before we turn it over to our presenter for the afternoon. Typically, the presentation lasts between 30 to 40 minutes, and there will be time left over for a Q&A. You'll have the opportunity to submit questions to today's presentation by typing your question in the chat pane of the control panel. You may send in your questions at any time during the presentation, and I'll make sure to collect those and address them during the Q&A session at the end of today's presentation. And with that, I will turn the mic over to Carrie Schofield to introduce our presenter.
Hi, everyone. Thank you for joining us today. Henry is going to be the speaker, and he was admitted to practice law first in Minnesota in '95, and then he was admitted in South Dakota in '96. He's also been licensed to practice U.S. District Court, District of South Dakota, and in the Cheyenne River Sioux Tribal Court. Henry has been, to my knowledge, I think Henry's probably been the longest practicing immigration lawyer in South Dakota. And he's also my go-to for all of my questions, and so we're really lucky to have him share his information with us. And thank you, Henry.
You're welcome, Carrie. And when I was asked to do this, and we talked about this in the Immigration Committee, and with the limited time, I decided just to focus in on the marijuana issue and the criminal consequences that marijuana can create for somebody who is not a U.S. citizen. And that's the reason why I decided to focus in on this and not on other crimmigration issues. And I created I'm afraid of making PowerPoint, so I kind of did an outline. And so I'm on page 2 of the outline. And all crimmigration issues will create 3 types of consequences. And by crimmigration, I mean that's where the adverse criminal consequences that the Immigration and Nationality Act imposes. So when a client is convicted of a crime, what will be the adverse immigration consequence? That's what crimmigration is. And the first type of adverse immigration consequence is what I call an inadmissibility issue. And if you have a certain type of criminal history, one may not be admitted into the U.S. And when the person is already in the U.S., they may be deemed inadmissible when they leave and they're applying to come back into the United States. Or they may have some other type of status in the United States and they have not yet become a lawful permanent resident, or what we call a green card holder. And when they do become a green card holder, there will be an admissibility issue at that time. So I just kind of wanted to define what immigration meant by the inadmissibility issue. And in my citations, I cite to the INA directly. And then in the brackets, I place the actual title code from the 8 U.S.C. And one will not be admitted into the United States if they've been convicted of a crime that involves moral turpitude or a controlled substance offense. And granted, under South Dakota law, marijuana is not a controlled substance. But since the federal government defines or lists marijuana under a controlled substance schedule, they're using the term controlled substance is broad enough to encompass marijuana offenses. And the type of criminal defendant that we may approach and that we may approach to have these issues would be the lawful permanent resident, or LPR green card holder, or it could be a refugee who has not yet become a lawful permanent resident, or it could become a non-immigrant visa holder, such as a student, F1, or maybe a high-tech worker, an H1. If there's a letter next to the visa name, they're probably a non-immigrant. And the undocumented. These will be the type of criminal defendants that would not be U.S. citizens. So the admissibility issue is the first type of consequence that a marijuana conviction can create. The second type of consequence is a removability issue. And in my experiences in removal court or deportation court, typically it's going to be the lawful permanent resident that is going to be removed. A refugee, they may charge him or her under removability section and not the admissibility check section that we talked about earlier. And that's more technical if you're doing deportation defense work. But you can be deported or removed if you are a person who has a conviction for a crime that again involves moral turpitude or an INA defined aggravated felony. I did not list them all here in this materials. I listed the statute, and controlled substances is a type of aggravated felony, but you can also be removed in its own separate provision of controlled substances and domestic abuse type of convictions. But for today, I'm going to focus in on marijuana. The third type of immigration consequence that can be occurred is here on the bottom, which would be the naturalized U.S. citizen. When a person applies to become a naturalized U.S. citizen, there's two standards. And those two standards are going to be that if the lawful permanent resident is convicted of an aggravated felony, and for some reason that person was able to remain in the U.S., that person is forever precluded from applying to become a U.S. citizen. For example, let's say you have a client who is going to plead guilty to some federal drug charges. And the immigration side, the person will most likely be able to stay because they have the required physical presence. The plea is entered. The federal drug charge is there. Person goes to immigration court. Immigration court approves the person's cancellation and removal application. But that lawful permanent resident will never ever be able to apply to become a naturalized U.S. citizen. And that is what the A point there is. That is different from the lawful permanent resident who may have had a drunk driving 10 years ago. And that standard for the drunk driving from 10 years ago is the person may not have had a criminal history within the last 5 years of filing the application to become naturalized until the time the person takes the oath of citizenship. And that 5 years also includes any type of probation time. And I know some of my colleagues who do immigration law may disagree with me, but I always calculate the no like offenses provision, if there is one in the judgment, as the starting point of that 5 years. So if somebody is convicted today, February 20th, 2020, a year from now would be January 20th, 21. That's where I would start my 5 years count to 2026 would be the earliest that the person could apply for citizenship. And no matter when the conviction occurred, immigration will always use a person's criminal history to determine whether or not that the person is a person of good moral character for the citizenship application. I had a client we interviewed, turned out he had a simple assault out in Pennington County in 1969. And that's almost 50 years ago. It wasn't 50 at the time. but it was still a good 47 years from the date of the offense. And I'm sharing that to show that immigration will look at offenses that go back during the person's lifetime. And what I am seeing, and I don't know if Carrie, if you're seeing this, and I know this is happening within the two AIDLA districts I'm a member of, immigration is looking for a certified copy of the police report, which may exist or may not exist by the time you're filing for the application, a certified copy of all the pleadings that were associated with the criminal charge, whether it was an indictment, maybe an amended complaint, the transcripts possibly of the grand jury, the conviction, plea agreement. They want copies of all that information so they can determine the type of conviction underneath the categorical or the modified categorical approach to determine whether or not the underlying conviction has one of these three, has the consequence of being either being a deportable offense or being a conviction that created the admissibility one. So I just wanted to identify those three areas of the immigration consequences that are there before we start to look at the marijuana convictions. And because the legalization of marijuana and the legalization of marijuana-related products have become so prominent in our societies, I just wanted to let everybody else remember that for immigration purposes, marijuana can create adverse immigration consequences. Under the admissibility approach, there's no exception for the one-time use of marijuana. But under the deportability ground, there is. So in this hypothetical is, let's say we have the college student. College student is arrested for ingestion. The underlying influence there was marijuana. And for removability purposes, the marijuana was less than 30 grams, so the student will not be placed in removal proceedings. But when the student leaves the U.S. to go home for a while before returning to South Dakota, that student then will have an admissibility issue. And there's really no waiver for that admissibility issue. The student will have to apply for permission to re-enter the U.S., but typically the State Department makes the student remain outside of the U.S. for more than a year. And during that year period, to demonstrate that the student does not have a drug problem. And where you see this situation, besides in the marijuana ingestion type cases, is with student DUIs. And if that's the situation, being a DUI where alcohol is the influencer, the student has to prove they don't have a drinking problem before they're able to come back. And big difference there between the admissibility issue and the removability issue. Admissibility means you can't come into the U.S. And where I've seen cases happen is somebody may have had a controlled substance offense, and they've been going back and forth to Mexico from time to time. And finally, that Border Patrol person says, look, you've got this controlled substance conviction. We're going to let you in, but we're going to let you in a status called deferred inspection, but we're going to place you into removal proceedings because you're not admissible. And then the immigration court needs to decide whether or not that person has a possibility of staying here. That's where the admissibility issue will occur, is when the student or the person leaves the United States. But from the criminal defense side, the attorney needs just to remember that the admissibility issue is much, much different than the removability issue, because removability means we're going to deport you from the United States and we're going to not allow you to stay here. And there is the 30-gram exception for one's use in removability, Section 4 marijuana. And underneath that exception, you really need to prove that a measurement of the marijuana. I know it's a challenge because South Dakota uses ounces, the feds use grams, and our first-degree misdemeanor, the 2 ounces may be more than 30 grams or maybe less. So it's really imperative to have the measurement of the marijuana being determined. And if that's possible in an ingestion type cases, to have that also measured. Because even though state law defines that differently, as long as it remains in the federal immigration code, the one-time use of marijuana, it will still be there to create adverse immigration consequences. As for the naturalization issue again, the one-time use may allow, the person still may be able to apply for citizenship down the road if that's the only marijuana conviction or controlled substance conviction the person has. If the timing of, by timing I mean the conviction has ended, any no-like offense period had ended, any type of probation had ended, fines that needed to be paid were paid. If all that has occurred beyond 5 years ago, the person would be able to file. If it's 4 years and 366 days, it's still not the full 5 years. That's what I meant beyond the 5 years. But if the drug matter conviction was something more than the one-time use of marijuana, that permanent resident probably would not be able to become a U.S. citizen because of the aggravated felony area. The other matter I wanted to maybe list what types of arrests that you may see these issues, so that way you can be spotting the immigration issues, would be arrested for marijuana, arrested for the paraphernalia, and arrested for driving while intoxicated. And this is where marijuana would be the influencer, but I don't know how easy it is for law enforcement to make that determination for that DUI context based upon some of the reports and the news coming out of Colorado on the legal use of marijuana in that state. And I would, Beth, if anybody had any questions, I would be happy to answer them.
Great, thank you, Henry. It looks like we have no questions currently in the queue. Again, if you would like to ask a question, you will need to use the chat pane in the taskbar panel through GoToWebinar, as all attendees are in listen-only mode. So I would turn it over to Carrie Schofield to see if she had any questions at this time to allow for people to maybe place questions in the chat task pane.
Hi, Henry. I saw an interesting question the other day about now that marijuana is legal in some states and maybe somebody is working for one of those companies, that presents some different issues too. Do you have any thoughts on how to advise on that one?
I would, if you've got the employee, they happen to not be a U.S. citizen and they're transporting the marijuana and they're maybe caught in South Dakota with it. Is that the type of question? And that would create a immigration issue at that point because of the possession, even though it may have been illegal in South Dakota.
Mm-hmm.
Would that be, is that, or there more to
Yeah,
your
that's another
factual
take
pattern?
on it too. That's another take on it too. That's
But what was your take on, I mean, on the facts that you gave me? Because I don't think I hit it.
This was advising somebody that was going to take a job where part of the company had ownership in one of the legal facilities. So even though they weren't using or it wasn't illegal where it was, it would still cause immigration consequences for perhaps with the control. I forget the language of the statute. You would know better than me.
I mean, it might with the underneath the distribution maybe side of it, but if you're distributing it only where it's legal, then underneath that state law, it wouldn't be illegal, but under federal law it might be. And because I don't know how the feds have yet to reconcile that with the states, where under federal law what the business is doing may be illegal, but under state law it may be perfectly legal. But since the Fed law it's illegal, that's where the immigration issue would manifest or would become ripe, I would say. So it would be a very dangerous spot for that non-citizen to be in. Because underneath that.
It's so messy now with the.
You just don't know how the federal government's going to respond to the state law that allows marijuana versus the federal law that says, hey, it may not. And until that's reconciled, that's the reason I would just say, theoretically speaking, it would be problematic for that employee.
Okay. That's if we. Yeah, I could ask Henry questions all day long. So you'll have to tell me if there's any that come through.
Yep, we do have a couple of questions. So Henry, the first question is from Bob Pisal, and he says, if I recall correctly, some states have civil penalties for low-grade drug matters. How does that play with the INA?
The INA is going to be, Bob, it's going to be real narrow. And if it's a controlled substance that the client is convicted of, it will most likely be an INA violation. The only exception for that is the 30 grams of one's use of marijuana. And that opens up a door as to saying, well, let's say if you look at wax, which is a marijuana byproduct, is that a controlled substance or is that marijuana? And that's something as a prosecutor or as a defense attorney, that language has got to be in the conviction to define what that is. And Bob, I also owe you an email too. My colleague up in North Dakota gave me more information on that pardon question that I floated around, and I wanted to send her information back to you on Professor Barron's listserv, and I have not forgotten to do that. But if it's marijuana, that's where it is. That if it's marijuana, then less than 30 grams, you should be okay from being removed, but you still have the admissibility issue coming back in with that. And that's kind of where you got to have the state court to decide what it is. And I know there's some different case law out there in South Dakota to decide the difference between marijuana and other controlled substances that use marijuana ingredients. Beth, any other questions?
Yeah, there is one more question here from Brenda Zilstra. Hopefully I'm saying your last name correctly, Brenda. The question is, do you think the USDA's removal of hemp from Schedule 1 of the Controlled Substances Act makes it easier to make the argument to have marijuana being removed from Schedule 1?
I do think it would be easier to make that argument, but whether or not Congress will act on that, I don't know, because you've got people in in the federal government where many still see and perceive marijuana as being that gateway drug to other drugs, such as heroin. Whether that's scientifically proved or not is a different question, but I remember when Attorney General Jeff Sessions had made a speech about marijuana being a gateway drug, people had criticized him for making that statement, but as long as that impression of the gateway drug and marijuana is there, that's the challenge I see with it being removed from that schedule.
All right, and those are the only two questions that we have in the queue. So I would turn it back over to Carrie if you have any additional questions, or Henry for any closing thoughts.
I kind of want to follow up on that interview, on that schedule question that was just asked by Ms. Ostra, because let's say South Dakota defines a drug as a controlled substance, but for whatever reason, the federal government has not defined that drug as a controlled substance. Then there would be no immigration violation. And I know there was some litigation going in Nebraska where people were being placed in removal courts in the Omaha court for controlled substance violations. But under Nebraska law, it was a controlled substance, but underneath federal law, it wasn't. So the immigration court had to dismiss the deportation cases. So understanding what's on the federal schedules in contrast to what's on the South Dakota federal schedules, controlled substance schedules, will make a difference for your analysis when looking at non-marijuana but controlled substance offenses, if that makes any sense.
All right, and now I'll turn it back over to Carrie if you have any other questions for Henry.
I don't think so. Henry, did you touch on when, like, how was it 1991 that if the convictions were before 1991, is that when it was?
Well, I know the drug schedule came into play about 1986 when Nancy Reagan was doing Just Say No to Drugs and doing the A commercial on TV.
Okay.
And I know in 1996, Congress changed the immigration law and created the Illegal Immigrant Reform Immigrant Responsibility Act. Newt Gingrich and President Clinton signed that law, and that's when the current law, that's what we have. And that was in 96, and I think it was convictions after 89 or 90 about being applied to that for aggravated felonies and other things that may have occurred in the early 90s, like 1991. If you had a conviction that was on that date and going forward, then the new law would apply to you. And if you hadn't, then the old law wouldn't apply to you unless if you left the U.S. and then you came back in and you had to prove yourself to be admissible. Is that what you're kind of asking about, Carrie?
Mm-hmm. Yep.
And
so
I just don't see. Go ahead.
I was just going to say, sometimes with those really old ones, you get a new set of rules. But
yeah, and I know the president wants to do like a merit-based system, very much like what the UK is doing now, since it's left Brexit. And I don't see, if that law were to come in play, that the administration would like to go, I don't see IRA going away. I don't see these provisions going away in the future, because they're still going to want to have some kind of grounds of how to remove people, even though they're going to create new laws that's saying, hey, these are the certain people that can be admissible to the U.S. because they've got these kind of points for permanent jobs. One thing I did not put into the materials and a lot of situations I have seen has been where maybe you would have a person that would represent themselves and can't speak the language. And I don't know, and there was a translator in the courtroom, but I don't know if hey, if you plead guilty to this, it will have immigration consequences. So be very careful before you plead guilty on the record. And then the person will plead guilty to, let's say, possession of marijuana less than 2 grams. And then they're coming back into the United States and then they get caught. And now you're trying to vacate or doing a motion to withdraw your guilty plea. And that's a program I think that we should, work with the criminal bar side on to take a look at that, because I had that encounter and I did get the conviction vacated, but it was weird because the person was arrested for immigration purposes in the Fifth Circuit, which was Texas. And since they were in the Fifth Circuit, they choose to say that if a guilty plea is vacated or conviction is vacated for a constitutional purpose, we're still not going to recognize it as being vacated. We're going to still say that that's a conviction. And in that case, the government agreed with just to terminate the proceedings against the client. But that's just something to keep in mind too, is that the accused, the defendant, the convicted defendant may have an immigration issue that might be outside of the Eighth Circuit. And then how that circuit interprets the immigration law will review whether or not that the conviction was vacated. And it's just like the Fifth Circuit's just an anomaly on that issue. And that's just something I wanted to bring up.
Well, it looks like I'm sorry, I was just going to say it looks like we have one more question in the queue.
Excellent.
And it is, in your opinion, do you think these admissibility and removal restrictions are unfair or too harsh? And is there any justification for these standards?
There are some harsh removability provisions. And that's what Congress had created. And I don't see those standards being changed. Depending upon the facts and the circumstances of the individual who's in removal court, they may or may not have the ability to stay here in the U.S. I have worked with many young people who came into the U.S. as refugees, and then they became a permanent resident, and they had enough time in the U.S. before they had gotten their marijuana convictions. And they were detained over in Albert Lea, and then they were able to receive what's called cancellation or removal. It's a process you go through, and it's kind of like a suspended imposition, and it's basically you can stay. But after you have that first cancellation or removal, you can't. Where the challenge is when Congress changed the act in '96, the act that Karen and I were talking about earlier, the person who is not a permanent resident, they have to prove 10 years of a physical presence, and that they have to have a qualifying relative that would have an exceptional and extremely unusual type of hardship, which is a very, very high standard to meet, almost impossible. And the history of immigration law is it seems like the more we reform the law, the harsher it becomes. And that's kind of a history in that sense. And that's sort of where the law is, and I just don't see Congress changing that. There's too much anti-immigration lobbies and movement going on where I just don't see that being changed. That's an excellent question. And it's also an excellent kind of social studies type of question too, because when Congress does propose new rules or new laws in that sense, we can really get a hold of our Congress people to try to influence how they're going to vote or not vote. And though this is not criminal law, Governor Nome, welcomed refugees to South Dakota, which was kind of out of lockstep with the administration. And I know many of our colleagues wrote her a good, strong thank you note on that. So when we do see positive stuff also within the immigration community, we ought to thank our leaders too on that side, because they're not hearing enough from people who want to reform immigration law that's going to further the benefit of immigrants. They usually hear more so on the we got to restrict immigration side, almost like a 5-to-1 type of ratio. Somebody once told me at Senator Thune's office when it comes to new legislation. But that's an excellent question.
All right, well, it looks like we are to the end of our questions in the queue. So Carrie, I'll see if you have any follow-ups for Henry.
No, thank you.
Okay, great.
Thank you.
Henry, any final thoughts that you'd like to leave the group with before we close out the webinar?
Anybody's most welcome to get a hold of me, and if you need some information, let me know. I've always have kind of worked with people on that for the last 20 years, and be more than happy to answer people's questions offline.
Great. Well, and we have currently your contact information up on the screen for those to be able to see. The CLE materials will be available online, and they will also, we can send them to you. So if you'd like to get a copy, feel free to send me an email at elizabeth.overmo@sdbar.net. And just want to thank you, Henry, for presenting, and Carrie for chairing the Immigration Law Committee for our state bar, and for introducing Henry. Once you leave today's webinar, you'll receive a survey on this presentation. We'd appreciate if you could complete that and provide your feedback. And then you should receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar. The handout materials are also available if you're viewing this online in the task pane under the handouts section, so you can download them there.